Yep, there we go. Marcy's on. Yes, sorry about the delay.
I asked that.
Yeah, yeah.
Coordinated today.
So,
Are we good?
yep, I think so. Everything's on. If you want to start the recording, then we're good to go.
It's are on. Start recording. All right, I'm going to call the meeting to order at 1:19. And we will start off with roll call. So Commissioner White, I'm here. Commissioner Ordaz.
Here.
And Commissioner Monsanker.
Here.
Commissioner Quaker.
Here.
Commissioner Ducat.
Here.
And Commissioner Kennedy.
Here.
We'll start off doing recognition of staff, interns, public, and the press. We can start now.
Kristen Stifler, Executive Director.
Joe Austin, attorney.
Katie Fiala, Assistant Attorney General. Caitlin Smith, Public Service Manager.
Tyler Eason, Assistant Attorney General, serving as a legal advisor to the board.
Do you have anybody else online that we need to acknowledge?
I see that we have, it says BB, I'm going to say that's Brenna Borman is on, Civil Rights Specialist, Fred Sienkiewicz, Civil Rights Specialist, Jacob Benningston, Civil Rights Specialist or Attorney, and Zachary Engstrom.
Then next on the agenda here is the approval of minutes from the September meeting.
Any comments?
Yeah, there are a number of typos and grammatical errors and other things. I think we should distribute it in a Word format and let commissioners provide recommended changes and then approve it at the next meeting. I'm certainly not going to vote to approve it.
Other thoughts?
Don't see harm in continuing them. For Commissioner Monsager's request. Rather see that than a split vote on the minutes.
I also have one other quick comment, and I'll pass this down the road. I've got a copy of the minutes from the boards and commissions review committee meeting. It's a very simplified form. They just record who's present and action taken. And our minutes go well beyond that. And I don't know what requirement we have with regard to minutes, but we certainly simplify things for everybody, the staff included, if we went to this more simplified form of minutes. And we can certainly consider that in the future. I'll just pass it around so that others can see what it looks like. And it's a much easier form. And quite frankly, I don't know what statutory or regulatory requirement we have for creating minutes. So I don't know what the rule set is for that. But anyway, I think we could go with a more simplified version that would make it easier for everybody.
We discussed that before the meeting started too, that I think that we would all be open to that being added to next month's agenda item and just taking a vote and reviewing with you guys what are, if any, limitations on how the meeting minutes need to be presented as. Right, so does someone wanted to do a motion to continue?
Can I make one comment?
Yep.
The commission will also need to have a separate set of minutes for the working session.
Yep, thank you.
I'll offer a motion to continue and then ask for a set of minutes for the working session as well.
Second.
All right, so moved. And now we will go to public comment, oral or written.
We should vote on that.
Okay, sorry. All right, we'll vote.
Discussion.
We'll vote on the motion for continuance for the September meeting minutes, and then also that we need to add the working session meetings to that as well for the next meeting. All in favor?
Aye.
Aye.
So moved. Now we are on to public comment. Anything that's written or oral.
I do not show anything.
Comments? Next on the agenda is the ICRC hearing.
Before that, I believe Commissioner Ordez, do you have an announcement?
Yes, can you guys hear me okay?
Yes.
Okay, I just wanted to make sure that everybody knew formally that we did receive notification from Dr. Kit Ford yesterday in written form to myself and Executive Director Stifler that she is resigning her position as a commissioner for the Iowa Civil Rights Commission. She found that her time just was not allowing her to commit what she would want to commit to do the work of this commission. And she appreciated everybody's welcomeness and her opportunity to have served for the short time that she did. So we will be down one commissioner.
Give her our thanks when you talk with her.
I will.
All right, so now to the ICRC hearing, Iowa Civil Rights Commission versus Anita Elaine Razanka and Joseph Laura Razanka. And we will go into closed session for that.
Well, we'll have arguments.
Okay.
So we're gonna say, Assistant Attorney General, would you like to give an overview again of what that process looks like for the commissioners?
Thank you, ma'am, and may it please the board, or the commission, excuse me. Again, my name is Assistant Attorney General Tyler Easton, serving as legal advisor. Members of the commission, this hearing is governed by Iowa Administrative Code 161-4.23. Basically, what that entails is that this is a review of a proposed decision on appeal to the commission. The party that has appealed has done so in a timely fashion, provided the notice of appeal. What happens today is oral argument to this commission. Rule sets out that each party is granted 10 minutes. However, that may be adjusted or lengthened at the discretion of the chair or vice chair, excuse me. And then at the end of all arguments, then the board, or excuse me, the commission will go into closed session and discuss the arguments made by counsel. At that point, the commission can affirm, modify, or reject any of the findings made in the proposed decision. The commission also is allowed to remand back to the ALJ for further proposed findings of fact, conclusions, or other additional evidence. So that's the lay of the land. If it pleases the vice chair, I do have a question for counsel prior to opening arguments, if that's acceptable.
Yeah.
Thank you. Mr. McGinn, are you on the call?
I think so. I just allowed him to talk.
Okay, thank you. Mr. McGinn, are you able to hear me?
I think I'm on now. I'm unmuted.
Yes, no, I can hear you. Thank you, sir. My name is, again, Tyler Eason, Assistant Attorney General. Prior to argument, I wanted to assist the board in addressing what you have filed in this matter as exhibits. You filed exhibits 12 and 13, as well as respondents list 12 and 13 on October 19th, 2023. Can you explain, or at least provide as to why?
Yes, let me explain that. I have another matter going on, and those were filed in error, and I'd like to withdraw those two exhibits. They should have been filed in a district court action that I'm actually in trial for today as well. So if we could withdraw those two exhibits, that would be helpful.
All right, that makes much more sense. So, Madam Vice Chair.
I thought it would. Yeah, my
Vice-
apologies for that.
Madam Vice Chair, the respondent has asked to withdraw those exhibits. Does the state have any objection to that? To withdraw those exhibits? No objection, all right. So without objection, it's up to the board, but I would advise that the withdrawal of the withdrawal of those proposed exhibits are acceptable and should be allowed.
Do we need a motion to vote?
No, you can make that decision.
Consensus of the group? You good with that? Yes, yes.
Okay. At this point, ma'am, it's your hearing. Respondents normally will go first, then the state, and then the respondents have the right to rebuttal for your remaining time that you grant them.
So we'll allow the respondent.
Mr. McGill online.
Excuse me?
When you're ready, sir.
When you're ready.
Oh. Well, basically, we've, as far as my argument is concerned in support of my brief, basically we laid out the main decisions or the main reasons why we disagree with the finding that Ms. Anderson basically didn't give notice that she would have a pet. In other words, there was things that she brought in after she got herself into the house, but didn't totally disclose to the appellants everything that she was planning on doing with the house. They had problems with the rental agreement, and all that is basically set forth in my brief. The other thing that I would notice, or the main thing I wanted to bring across today, was the amount of penalty that was assessed against the appellants. There was really no evidence to show that Ms. Anderson actually suffered any damages that would result in that amount. That appears to be the maximum that they can withdraw, and it's basically akin to hitting them with punitive damages, which really isn't appropriate here. She talked about some additional expenses she had because of a change in taking her kids to school as a result of this and so forth. But had she been evicted, that would have limited the amount of time of exposure she had to that to just a few $100s. So that was the main point I wanted to bring up on appeal. Otherwise, I would say if there's any other questions about the balance of my brief, I would just show that the brief, our other issues are as submitted in our brief.
At this point, if any commission members or any individual commissioners have questions for Mr. McGill, you may feel free to ask them now, or I don't know if he'll present rebuttal evidence or rebuttal argument, excuse me. So I would say if you have questions, ask them now.
Can I ask a question? Mr. McGinn, I don't know if you can you see us through your screen,
No,
or are you just
I've
listening?
actually had to call in on a phone. I was unable to get logged
Okay,
in on
so
Zoom.
So I'm Sam Quaker, one of the commissioners, and so my question for you is do you maintain the position that you believe that this animal was that Checkers was a pet?
Yes, there was really she had one letter, but there was really nothing to certify that Checkers had any training or any way, shape, or form, nor formally recognized as a service dog.
May I ask a follow-up question?
Sure.
So my follow-up question is, did your client ask for such justification?
I don't believe there's any evidence that they did. The dog just appeared, and it's our position that Ms. Anderson made no effort to disclose or show that Checkers was a service dog until it became an issue. And had she been a service dog at the beginning, it's our position if she'd have disclosed that, then accommodations could have been made and so forth. But it's like the lease was entered into, she moved in, and then it's like, oh, they find out later that she has a service dog. There's no evidence on the record that she ever disclosed that to them prior to the lease or at any time before bringing Checkers into the house.
So regarding last question for now, regarding in reading the ALJ's decision, so it appears that there were a number of inappropriate comments, demeaning comments that were allegedly made by your clients. Do you dispute those comments were made? Or and if they were made, do you consider them simply off-color comments, or do you consider them in another vein?
Well, we had a hearing in district court where they were where Ms. Rozanka, who made the comments, was charged with harassment. She was found not guilty. And as the judge put in there, there's no requirement that you have to be polite, but our position is that these were off-colored comments. Yes, they probably shouldn't have been made, but they don't rise to the level of any form of discrimination.
Further questions?
Any other questions? So next, we will have the Iowa Civil Rights.
Better grab that wall here, just. Thank you, Commissioner White, Commissioners and Council. My name is Joe Austin, and I'm an attorney with the Iowa Civil Rights Commission. And I'm here today to argue that the judge assigned to this case correctly determined that the Rozankas discriminated against Brooke Anderson. Specifically, the agency alleged, and the judge, after holding a hearing, reviewing the evidence, and observing the witnesses, determined that the Rozankas violated the Iowa Civil Rights Act in 3 ways. First, they denied Brooke's request for a service animal, an emotional support animal at reasonable accommodation related to her disability. Second, they harassed her based on her disability. And third, they retaliated against her for obtaining that Checkers, the emotional support animal. Let me walk you through each of those. First, the judge determined that the Rozankas denied Brooke's request for a reasonable accommodation. And this charge has 5 elements. Brooke is a person with disabilities, and this is not disputed anywhere in the record. She's been diagnosed with major depressive disorder, PTSD, and generalized anxiety disorder. This is not really an issue in this case. Second, we know that the Rozankas knew that she was a person with disability. Elaine Rozanka testified that everybody all over town talked about how crazy Brooke was. And when they spoke with Brooke, they routinely referred to her as crazy, as mentally crazy, they referred to her mental conditions, multiple conditions. Third, we know that Brooke's request for an emotional support animal was reasonable. This is a request we see all the time. She requested 1 service dog to live in a house, a duplex with a yard even. The dog she chose, Checkers, who's a Shih Tzu. They're about 10, 15 pounds, the size of a house cat. And at no point during the investigation or the hearing or after any part of during the litigation have the Rozankas introduced any evidence that this request was unreasonable. And then finally, we know that the Rozankas refused Brooke's request. Brooke asked Joe Rozanka first in kind of an informal conversation, and then later in a letter specifically laid out what her disabilities were and why she was requesting the animal. The Rozankas replied in writing 3 days later, telling her she had 3 days to get out of the house or get rid of the dog. Very clear. Moving to the second charge, the judge also found that the Rozankas harassed Brooke based on her disability. As we already discussed, Brooke is a person with a disability and she's protected under the Iowa Civil Rights Act. Second, I'll try not to belabor this, but the Rozankas' conduct was unwelcome. We know this for a lot of reasons. Eventually, Brooke had to set up her phone so their phone calls would go directly to message so she didn't have to suffer their verbal abuse anymore. At one point, she actually had to contact the police for protection against the Rozankas, and ultimately she moved out of a house that she enjoyed living in to avoid further harassment. Other than the Rozanka's behavior, Brooke liked living in the house. She could afford it. And most importantly, she had two children school age, and the house was 2 blocks from their school. So she wanted to stay there as long as she can. Third, we know that the Rozanka's behavior was at least in part motivated by Brooke's disability. As is all over the record, Joe and Elaine, when talking to her, would call her crazy, say that she was psychotic, that she was a mental case. Joe Rozanka admitted during the hearing that he told Brooke that she was nuttier than squirrel shit and that she needed to lie down and take a Xanax. No question that the behavior was based on her disability. Finally, we know that harassment was both severe and pervasive. I've already talked about some of the offensive language that they used. I apologize in advance for this. I do not want to do this, but we're talking about harassment and the facts really matter. Elaine also routinely called Brooke a bitch and a cunt. This is more than enough to establish severe and pervasive harassment. This occurred over 2 years, but the Rozankas weren't done there. They also physically threatened Brooke. Both Joe and Elaine on separate occasions threatened to send people after her because she had a dog in the house. They also, at times, attempted to legally evict her. And finally, when that failed, they took the extrajudicial method of trying to scare her and threaten her into leaving the house. And this was in July 5th and 6th of 2021 when this culminated. Brooke woke up that morning and heard strange, loud sounds coming from the other side of the duplex. She began to listen, and over time she started to recognize some sounds. There was heavy metal music, followed by hammering and banging, followed by the sound of chainsaws and people screaming. She didn't know what to do. She knew that the other side of the duplex had been vacant for over a year. She had first called one of her friends to come over to try to figure out what was going on. Her friend knocked on the door, no one answered. They eventually called the police. An officer showed up, knocked on the door, looked through the windows, determined that no one was in the house. And as they listened, they realized that these sounds were on loop. They would repeat themselves after a period of time. And they concluded based on that there must be some sort of recording playing over speakers that was set up to scare and disturb and bother Brooke. As Mr. Regan pointed out, that actually resulted in criminal charges. I won't go too much into the weeds there, but criminal harassment is a different charge than civil harassment. The fact that the Rozankas were acquitted of the criminal charge does not mean that they did not harass Brooke under the Iowa Civil Rights Act. The judge discusses this in detail in her decision. I point you in particular to footnote 13. The judge in this case had the opportunity to listen to multiple witnesses and to assess the credibility both of the Rozankas and of Brooke and the other people she called to testify, and determined that that did in fact happen. Finally, the agency alleged and the judge determined that the Rozankas retaliated against Brooke for obtaining checkers. Her request for the service dog was reasonably related to her disability. We know that. In the record was a letter from her medical health provider saying that she needed an assistance animal. And we also know that it did her a lot of good. When Brooke first moved, and I just will point this out to be clear, Brooke did not move into the house with a dog. She didn't have checkers when she moved in. She was suffering from her conditions. And actually, shortly after she moved in, she was hospitalized because of complications with her disabilities. After 6 or 7 months in the house and speaking with her therapist and taking her therapist's recommendation, she obtained a service dog, an emotional support animal, checkers. After she did so, we know that her conditions improved. She no longer needed to seek inpatient treatment. She was able to reduce the amount of medication she was taking. And perhaps most tellingly, she went from unable to hold down a job for more than a couple months to not only obtaining full-time employment, but maintaining it to this day. Checkers was a clear benefit for her. Second, the judge determined that the Rozankas retaliated against her both by increasing their harassment that we already talked about and intensifying it, and second, by trying to evict her. And here the record is abundantly clear. She sent them the letter explaining her conditions, that she was going to get a dog. 3 days later, they replied in writing, get rid of the dog or get out. After that point, they made multiple attempts to evict her, both legal and extrajudicial. Third, the judge determined that the reason that the Rozankas continually tried to evict her was checkers. And the Rozankas acknowledged as much. We talked about the letter they sent her 3 days later saying, get out or get rid of the dog. When they spoke with her in person, they continually complained about checkers and told her she needed to get out of the house if she was going to have a dog. After several attempts at intimidation, they did hire a lawyer at one point to try to evict her legally. The lawyer sent her paperwork saying that they were going to evict her and listed 6 reasons they were going to evict her. 2 of those reasons were about checkers. They said she had an unauthorized animal in the house and that there was a dog running wild on the property. The Rozankas have maintained that the reason they were going to evict her was because she was failing to pay rent on time. They didn't list that. Their attorney didn't mention that as a reason they were going to evict her. In addition, Investigator Borman with the commission spoke with the Rozankas, interviewed them before the trial began, routinely asked them to provide evidence that Brooke was failing to pay rent on time, asked them for ledgers, for receipts, for bank statements. None of that was ever provided in this case. And the judge, I think, appropriately dismissed that argument out of hand. It just didn't hold water. The Rozankas testified again and again. They don't allow animals of any kind. Doesn't matter if it's emotional support animal. Doesn't matter if they can prove it. They don't. As Joe said, no pets means no pets. End of argument. I'd like to briefly bring up just a couple things in rebuttal to Mr. McGinn's argument. First, as we mentioned, Brooke did not have checkers when she moved into the house and keep it a secret. She got checkers, and the testimony is 2 or 3 days later had an informal conversation with Joe about whether there would be a deposit required or whatnot. And then a few days after that sent a letter explaining in detail why she was doing that. I think that we're still in the no pets is no pets territory. It is irrelevant that Checkers was not certified by a formal institution as being able to perform certain tasks or certain ticks. We're not talking about a seeing eye dog. We're not talking about a service animal. We're talking about an emotional support animal for her mental conditions. Third, just to be clear, the judge did not give Brooke the maximum amount allowed or anything close to that. The commission asked for $25,000 in damages, which we thought was entirely appropriate. The judge discussed in detail why she lowered that amount, but felt that $10,000 was appropriate. You could read her reasons. That's pages 14 through 16 of her proposed decision. It's fairly thorough. I would also note, Mr. McGinn brought up travel expenses. The judge specifically denied her request for reimbursement of travel expenses, so that wasn't an issue here. I've been talking a lot. I'd love to hear any questions if you have some.
Yeah, Counsel, I have a question about damages. You asked for $25K and the judge determined $10K, and you haven't really addressed the issue as to what's the appropriate amount. That's probably the key issue of the whole case from my perspective. And do you have any arguments that to the effect that the award should be greater than $10K?
We're not asking the commission to consider raising the amount. We're asking you to adopt the judge's decision in full. As to why we think that amount was appropriate, there's ample evidence on the record. In addition to threatening to send people after, in addition to the extremely abusive and hostile language, the use of the C word, calling her crazy over and over again. There's also credible testimony the judge found in the record that Elaine would routinely try to enter the property without permission and without advance notice, including once actually came into Brooke's house while she was in the bathtub. And on another occasion tried to enter the house when Brooke was at work, but her children were home alone.
You're no longer asking us to increase the award? You're asking for the $10K?
Of course, the commission is free to do as they please, but we're asking you to adopt the proposed decision in full, which would mean
$10K.
Well, it's actually slightly more than 10K. It's
Well,
10,000, yes, in damages plus moving expenses were
I was a
included.
little confused. I thought your brief indicated you were asking for an increase in the award of damages, but today you're just telling me you're only seeking the 10K.
Yes, we're asking you to adopt the judge's decision as written. You certainly have the purview to consider that amount and decide whether you think it should be increased or decreased, but we're
I
not.
can take a look at your,
Absolutely, yeah,
but it sounds like you're asking for 10K today.
that's correct.
Just want to be clear on that.
Yep.
Thank you.
Other questions?
So you'd support a higher amount?
Well, we initially asked for 25,000 and we thought that was appropriate. The harassment, as we talked about, was really severe and it took place over about 2 years. In addition, because of the event when police were involved and the screaming and the chainsaws coming from next door, at that point, Brooke felt she had to get out as soon as possible. Not only did she have to move, but she actually had to move out of town to find a rental quickly. We didn't ask for the judge did not award travel damages, and we're not asking you to reconsider that. But as part of that, rather than living 2 blocks from school, she had to drive her kids about 18 miles to school in the morning and then to pick them up in the evening. I also think there's ample evidence on the record that the harassment that she suffered was specifically designed to torment and take advantage of her health conditions. Her friend, Crystal Jensen, who she called over to invite, listened to the sounds, said, this wasn't, in reference to the screaming and the banging and the chainsaws, this wasn't as if someone was doing construction in here. These were sounds you would hear in a horror movie designed to scare her and exacerbate her conditions.
Last question, if I can. So if this commission chose to adopt the decision with an amendment to increase the award, but substantiated the increase for the amendment, and increased the award somewhere between 10 and 25, would you support that increase in the award and would you defend it?
We would certainly defend it if that were appealed. We do think that's appropriate. We initially asked for 25 and we thought that was appropriate. That's what I have to say now. Other questions?
I'm still a little confused that your closing brief indicated that you believe that damages should be 25,000. In your argument, you say that you want us to uphold the ALJ's 10,000.
And I'm sorry if I'm mistaken. My understanding is the closing brief we filed with the ALJ request was 25,000.
Right.
So the brief we filed with the commission, which is a latter separate brief, we asked you to adopt the judge's findings.
So you've changed your position.
We believe that the judge's award is fair and we're not specifically asking for more. It doesn't limit what you can do.
Okay, I'm a little confused by that, but I'll just let that sleeping dog lie for that, I guess, but I don't quite follow that. Thank you.
I know that I've gone well over time. May I briefly summarize?
Go ahead.
Okay, thank you.
Finish that.
After reviewing the evidence in this case, observing the witnesses and holding a hearing, the judge determined Brzonka's discriminated against Brooke, that they denied her request for reasonable accommodation, that they harassed her, that they retaliated against her. We ask that you adopt the judge's proposed order in full.
All right, we will give the respondent time to.
Yeah, I have some brief rebuttal.
Okay, go ahead.
Yeah, just by way of rebuttal, of course, I reiterate my arguments I've made earlier. But as far as any change or the amount that was awarded, I'd ask the commission keep in mind that that while there was evidence presented of noise and things going on in the other half of the duplex, there was never anywhere presented any evidence that Joe and Elaine Brzonka, they only owned the place. But other than that, there's no evidence connecting them with the creation of any of that noise. It could have been squatters, could have been people working on the house, but there was nothing to show that they directed it or made it happen or caused it in any way, shape, or form by any standard that you set there. Also, keep in mind when she talks about her changes, and Brooke talks about her changes and having to do more traveling, This is our smaller towns in Iowa. There's only so many rental properties around. She didn't show that there's only so many places that you can go. So that's part of that is choices that she made. So it's matters beyond everybody's control about her increase any increase in the driving time that she may have had to get her kids to and from school. And otherwise, I just reiterate everything I put forward in my argument.
Any other comments or questions?
I have one more.
Okay.
So, question for the respondents' counsel. So this is Sam Quaker again. So my question, sir, is your clients deny the recordings being played in the adjacent dwelling?
Correct.
They deny it categorically?
Correct. Yeah. In other words, there's just nothing sufficient to show a justification of award of even $10,000 is our position. And there was no evidence to show that they were in any way connected to it, other than the fact that they own the building.
And the keys, correct?
Correct, yes.
No one living there.
There was no evidence presented whether or not there was anybody living there or not living there.
Any other questions, comments before we move to closed session? I appreciate you guys both presenting. Thank you.
Oh, we'll have you read.
So the commission will now move into a closed session pursuant to Iowa Code 21.51F. Government body may hold a closed session only by affirmative public roll call of either 2/3 of the members of the body or all the members at the meeting. A governmental body may hold a closed session only to the extent a closed session is necessary to discuss the decision to be rendered in a contested case conducted according to the provisions of Chapter 17A. And can I have a motion?
So moved. Second.
First and a second, now we'll vote. All in favor, second.
No, roll call vote. Need a roll call vote of everything.
Okay, roll call vote, sorry. Holly White, I vote yes. Commissioner Ordaz,
Yes.
Commissioner Monsager,
Yes.
Commissioner Quaker.
Yeah.
Just a second to get this going again. All right, we're recording and we are just coming back from closed session and it is 2:55. And so next on our agenda is the announcement of our findings, and I will pass it over to our council to discuss the commission's decision.
Thank you, Madam Vice Chair. After the discussion in closed session, I've been directed to draft an order in continuity with your discussions as follows. The Commission adopts and affirms Section A, the findings of fact. It affirms Section B, the findings of law. As to count 1, it affirms Section C. As to count 2, it affirms Section, I believe D, the third count. It also affirms the award of damages for moving expenses. It affirms the denial of damages for travel expenses, and it modifies the award of emotional damages to $20,000. So a written opinion will be drafted at your direction by me and submitted for your review and approval at the soonest possible date. Thank you.
All right. Next on the agenda is the director's report. which was provided to you via email. Are there any questions or discussion around that? Kristen, do you have anything you wanted to discuss verbally?
No, I do not, and I'm gonna pull mine up because my computer's not.
I have a couple of questions. You ready for that?
Yep.
Yeah, Kristen, on the Board and Commissions Review Committee report, indicating their recommendation was the Commission's authority should be thoroughly reviewed and clarified. I listened to one of the hearings. Do we know if there was any evidence submitted at the hearing that led to that recommendation?
No, I don't know if there was any evidence introduced.
Okay, well, I talked to Nate Ristow and shared my concerns. And we have new commissioners that weren't around when we had the discussions, but the issue had come up in the past as to whether or not we could make recommendations to the legislature. The particular issue was elimination of gender identity as a protected class. Commissioners that are no longer with us said that we had to be neutral and could not do that. But that neutrality language does not appear anyplace in the statute 216. And so we had a bit of a disagreement, but because that bill didn't make it through the funnel process, we never had an actual vote as to whether or not we should lobby against that bill. So I talked to Nate Ristow about that. He was the guy who drafted this recommendation. And I said that there was disagreement amongst commissioners as to what our role was with regard to legislation. So apparently that's the only evidence that Nate got since it didn't come up during the hearing. So the question that I think we need to address at the next meeting is to try to get a consensus amongst commissioners as to do we want to make a recommendation to the governor, or do we want to make a recommendation to the legislature, or do we want to lobby with regard to issues in the future? And that's because in theory, this report goes to the governor and it goes to the state legislature. And so that question will be right for review in the relatively near term. And do we want to have the statute clarified? Do we want to avoid that role? Do we want to be more proactive? You may recall that in the past, this commission recommended inclusion of gender identity as a protected class. And so if the bill comes up again to eliminate that protected class, we don't know what the new commissioners feel about that issue. But anyway, I think it's right for consideration at the next meeting as to how do we want to proceed? Do we want to make a recommendation to the governor or the state legislature?
Thank you, Commissioner.
Yep.
I will remind everybody that we have, as of last month, we put together a working session for those topics to be discussed. And so that will be back on the plan for November. We will dedicate some time to have those discussions, and so I would come prepared with your thoughts on that topic for next month. Any other thoughts, comments, questions?
I had one question about the expanding the minimum qualifications, which will make more people, which will provide for more applicants. I didn't quite follow that. If you expand qualifications, I would think you would have fewer applicants that would qualify.
Are you asking what we did in our changes for the MQ process for
In
CRSs?
September, ICRC expanded.
Sure. You're asking what we did?
Yeah, I just didn't follow how you could expand qualifications and have more people qualify.
Okay, so I guess I don't understand your question, but if you'd like me to talk about the MQ process and the things that we changed, I'd be happy to share with you, Dennis.
Is it like the job qualifications? Is that a document that we could just look at?
Yes, so
Share that document, that would be great.
you're looking for the civil rights specialist job description?
Apparently that was changed in September, yes.
Yes, I did get that changed. So you just would like to look at the document?
Yeah, I'm just
Sure.
curious as to
We
what it
can-
looks like. Because
we can-
before you arrived, we had a lot of discussions about, job turnover and qualifications and passing the bar exam. We went through a lot of discussions over that.
Sure, happy to send it to you.
Thank you. That's it.
Any others before we move on? All right, so the next agenda item is the vote on the Kelly versus Brown proposed decision submitted September 22nd, 2023. And so this is just a opportunity for the commission to not discuss the specifics of this case because we would need to, I believe, go into.
You'd have to, we would set, so.
Set for a date.
Yep, so we would start that process in our office with the respondent and set a briefing schedule. So what is in front of the commission, if you motion in for this, is decide whether or not the commission would like to review the ALJ decision. So that would be just similar to what you just did.
And we just, our motion today to
Yep,
decide if we're
affirm.
going to do that or not.
So if you believe that there was something that you would like to either disagree with the ALJ decision in regards to the findings of fact, the conclusions of law, or the damages, that would be what the motion would be for. Not necessarily specifically one, like that specific issue,
Just to review it.
but just so that we would
Process.
head into the hearing process, so.
Yep.
Okay. So for the sake of discussion today, I'd like to just offer a motion that no further review is necessary and the commission affirms the decision. Appropriate motion.
So you can't affirm the decision. So the motion is whether or not you would like to hear the decision.
I get it. So the motion would be it's not, I motion that as it's not necessary to hear the decline to hear the decision.
Is there a second?
Yeah, I'll second that.
All right, and then we'll have a,
Discussion.
is there any
As part of the
discussion?
discussion, I'm going to talk to our Assistant Attorney General and request a 2-minute training session for the commission at a future session on some of the issues raised in that case.
You can direct the questions to me. What are your questions?
Well, I'll share them with you
Perfect, thank you.
later. Katie and I had a discussion during the break. That's why I said that. But there were some issues in the case that I quite frankly, and Sam and I discussed, that we didn't fully understand or appreciate. And that's why it got on the agenda through Sam's direction. And so I'll share them with you and just ask for 2 minutes of training to clarify.
For the commissioners?
Yeah, for the commissioners, yeah.
Sure, I'd be happy to
I think
do that.
that's easier to, rather than to, review the case.
Sure.
Any other discussion before we vote? All in favor, say aye.
Aye. Aye.
And then that brings us to commissioners' reports. I do not have anything to report. So I'll move on to Commissioner Ordaz.
I have nothing to report today.
Monsignor?
Yeah, I just have 2 quick questions. As I review these cases, it appears to me that there's a need for training of landlords. I've been a landlord. In the Navy, you move around a lot on short fuse and you have to rent your place out. And I certainly didn't know all these rules. And I'm just kind of wondering if the general public is aware of the rules we've looked at, these landlord-tenant rules and assistance animals and the like. I wonder if this might be useful to provide some sort of Zoom training or something to.
That's a great comment. So we provide quarterly training in regards to housing for free to anybody who would like to attend.
Is it advertised on the website or?
Yep, it's available for anyone to, and we do provide that information as well as on our social media.
Yeah, okay. I just occurred to me as we're.
Yeah, we're on top of it.
Yeah. The other issue is, it's a little bit more complicated. There was the bill I mentioned before with regard to elimination of gender identity as a protected class, and it's also in the Republican Party of Iowa platform to eliminate that as a protected class. And I know my colleague here has been looking at the police cases. I'm wondering how difficult it would be for me to look at all the gender identity cases that have been filed to get a feel for what sort of conduct we would be sanctioning if we eliminate gender identity as a protected class.
So Dennis, as we spoke when I first joined as the executive director, I said that you can come in and we can work on any type of file you would like pulled, and we can do that at any time. You just need to reach out to me.
Determine if that's a pain or is that, I don't want to.
No, well, we're here to help support the commission. So if there's something that you would like to work on, we're more than happy to work with you. You just are gonna have to engage with me.
I just wanted to get a feel for how much work it was. I didn't want to impose a burden. I'd be interested from other colleagues. I mean, is that a waste of time, or is that an important issue for you or not? Or
I think it's an important issue, Dennis.
And I think that you have a lot of passion about this topic, so I think additional data points and information would be helpful for you.
And I think anyone who has an opportunity to read the work that our office does is wonderful. If you've been on the commission for a couple of years and you haven't read very many of our files, I highly recommend that you do that, because it helps kind of give a little bit more into the work that my hard staff, my staff worked really hard. And I think that'd be wonderful if you could spend the time to know the work that's being done in our office.
okay, well, I'll touch base with you, and
Great.
when would be a good time to sit down and take through files.
Yep, we're available. We even have a drawer for John. So
John.
his files sit locked up.
File upstairs.
That's awesome.
Okay, thank
Yeah.
you. That's it.
All right, Commissioner Quaker. Commissioner Taylor.
I'm continuing to reviewing some law enforcement. I was in this morning for a while before our meeting and reviewing. I only got through partway through one because some of them are quite thick.
Good cops or bad cops?
I wouldn't say good cops or bad cops. I would say, do I have some questions? But overall, I think the commission, the report on this one I was reading, what they concluded was on. When the one this morning was on dealing with domestic type stuff, and anytime you deal as an officer with domestic situations,
That works.
yeah, and you deal generally, obviously, the majority of the time is a male and a female, and so it's he said, she said type things too. So it's, there was a conclusion, I would, if I had to vote, I would affirm what they concluded and how they ended the investigation. But it's interesting, and so I really would encourage any commissioner to sit down and, like you're looking at gender identity. One of the things that I would like, and I don't know how we go about it, and that is how many of our either side respondents or our complainants are veterans. Get discriminated against or are doing some things. Because let's face it, there's a lot of veterans out there that suffer from PTSD as an example, that really struggle at times. And so, and I know that information isn't collected right now. How do we even doing that? Which kind of puts back at you as well.
Fort Dodge cops discriminated against me when I was in high school, searching my car every Friday night.
That's all.
Thank you.
Thank you.
Commissioner Kennedy?
Nothing to report.
So with that, we will set the next meeting, which we're sticking to the third Friday, which would put it on November 17th. At 1:15 for the working session, which will be an hour, and then we'll go into our normal commissioner meeting at 2:15. Meeting is adjourned.
Motion to adjourn.
I'll offer a motion.
Second.
Okay.
All in favor?
Aye.
Aye. Marcy?
You're good. You had a adjourn.
Aye. Thank you.
All right, conclude. That. Meeting at
The meeting is concluded.
Every
at
Friday night.
3:09.
Fort Cops would stop my car and search my car.
Ending it.
No probable cause.